Hi, my name is Joy Yin, and I'm a solicitor at K3 Legal. I specialize in employment and immigration. Today, I'm going to tell a few tips to business owners regarding employment agreement when hiring a new employee. The law requires that an employer and employee must have a written employment agreement. The employment agreement does not have to be long, but must include a few things: names of the parties, a description of work, a place of work, agreed hours of work, amount of wages or salary that need to be paid, and a clause explaining what happens when the parties encounter employment relationship problem, and if the employee has any personal grievance against the employer, they must raise it within 90 days. If the employer does not comply with this requirement, they could face a fine up to $20,000. There are a few optional clauses that could be considered to put into the employment agreement. One of the most used clauses is probably the trial period provision. Business owners are able to dismiss employee before the end of trial period if they have such clause in their employment agreement. And when the employee is being dismissed, they cannot challenge such dismissal. However, to correctly use this clause, a business owner must ensure a few things. Firstly, the employment agreement must include such clause in writing. A verbal agreement between the parties is not valid. Secondly, the employee must be given sufficient time to seek independent legal advice about the trial period provision. Thirdly, the trial period clause would only apply to new employees and not to existing employees. Lastly, all business owners should note that from 6 May 2019, only small to medium-sized enterprises that hires 19 employees or less are able to use this clause. Larger enterprises that hires 20 employees or more is not allowed to use this. There are other optional clauses that could be considered to put into the employment agreement as well. These optional clauses are confidentiality, restraint of trade, misconduct, and termination clauses. It is absolutely vital and crucial to have an employment agreement between the employer and employee because they govern the obligations and relationship between the parties. The employer should have a good written employment agreement because it will contain all the necessary clauses to protect the employer's business needs. If you have got any questions about employment law, please feel free to contact me or one of my team members at K3 Legal.